In the third judge's case, the Supreme Court will find out in case of the transfer of High Court judges, the judges of India should consult in addition to the collegium of 4 senior judges of the Supreme Court. In the third judge's case, 1998, the Supreme Court will find out in case of the transfer of High Court judges. In case of transfer to the High Court judges, the Chief Justice of India should consult in addition to the collegium of 4 senior judges of the Supreme Court. The Chief Justice of the 2 High Court, one from which the judge is being transferred and the other receiving him. Collegium of 4 people. And in the case of Supreme Court, four senior judges. In the first judge's case, the court held that consultation does not mean concurrence and it only implies exchange of spirit. In the second judge case, the court overruled a chain of inquiry about consultation, concurrence, and approval that advice generally the Chief Justice of India is binding on the precedent in the matters of appointment of the judges of the Supreme Court. The Chief Justice would tender his advice in the matter after consulting 2 of his senior-most colleagues. Binding on the precedent, but the Chief Justice would tender his advice in the matter after consulting 2 of his senior-most after consulting. Till 12 o'clock, 9 to but the Chief Justice will tender his advice on the matter after consulting 2 of his senior-most colleagues. Similarly, in the third judge's case, the court awarded the consultation process to the Justice with a consultation of the hierarchy of judges. The Supreme Court of the Chief Justice sometimes does not consider a consultation process to consult a collegium of 4 senior judges of the Supreme Court, and even if the judge is given in his opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Without complying to the norms and recommendations and requirements of the consultation process are not binding on the government. So first judge's case 1982, second judge's case 1993, and third judge's case it is in 1998. In the case of the I am studying polity, Lakshmikant. In the third judge's case, the Supreme Court opined that in the third judge's case, the Supreme Court opined that in the case of the transfer of the High Court judges, the Chief Justice of India should consult in addition to the collegium of 4 senior judges of the Supreme Court. And the Justice of the 2 High Court, one from the judge. Four senior judges of the Supreme Court, the Chief Justice of the 2 High Court, one from which the judge has been transferred and the other is receiving. In jurisdictions and powers of High Court like the Supreme Court, the High Court is vested with quite extensive High Court has been vested with quite extensive and effective authority. The highest court of appeal and the fundamental right of the Justice with the power to interpret the Constitution besides his advice and consult. The Constitution doesn't contain detailed provision regarding the jurisdiction and powers of High Court. It only lays down that jurisdiction and powers of High Court are to be same as related for the commencement of the Constitution. But there is one addition that the Constitution gives High Court jurisdiction over any matters which are ignored during the pre-Constitution, and the Constitution also confers some more additional powers on High Court, like legislation powers, subordinate constitutional powers, etc. Moreover, written powers of Parliament and the state legislature change the jurisdiction and powers of the High Court. Like the Supreme Court, the High Court has been vested with quite extensive and effective powers. Like the vested with powers to interpret the Constitution besides it has supervisory and consultative roles. However, the Constitution does not contain detailed provision with regard to the jurisdiction and powers of the High Court. It only lays down the jurisdiction and powers of the High Court are to be the same. Constitution, but there is one addition, that is Constitution gives High Court jurisdiction over the Constitution gives High Court jurisdiction over the reviewing matters which it did not enjoy in the pre-Constitution era. The Constitution also confers with the other provisions of more addition pass an High Court like jurisdiction over private superintendents, consultative power, etc. More weight and power of the Parliament and the state legislature to change the jurisdiction and powers of the High Court. It empowers the Parliament and the state legislature to change the jurisdiction and powers of the High Court, represent High Court areas of jurisdiction and powers, original with related supervisory control. A court of record power of judicial jurisdiction and powers of the High Court are one with the Constitution provision that later is made in the Acts of Parliament, the Act of State Legislature in Penal Code, CPC 1970 and Civil Procedure Code 1902, original jurisdiction. It means the power of a High Court to hear dispute in the first instance, not by way of appellate action to the following matter of admiralty and contempt of police to the election of member of Parliament and state legislature regarding any matter or an act of the revenue collection. Enforcement of the power of certain cases order to be transferred from a subordinate court involving the interpretation of the Constitution to its own by the High Court, that is Calcutta, Bombay, Madras and Delhi. High Courts of original civil jurisdiction cases. Allowed by 1960, the four courts, Calcutta, Bombay, Madras and Delhi High Court of original civil jurisdiction in cases of high value. Before 1970, the Calcutta, Bombay, Madras High Court also had original criminal jurisdiction. Jurisdiction in cases of high value. Before 1970, the Calcutta, Bombay, Madras High Court had also original criminal jurisdiction. This was fully abolished by the CPC, and this was fully abolished by the CPC in 1970. Blood jurisdiction Article 226 of the Constitution pass High Court issues including habeas corpus mandamus, certificate prohibition and covenant of enforcement of their power on the citizen and for any other purpose for the enforcement of the FR and the subordinate acts for any other purpose. Phrase became the purpose of the enforcement of an ordinary legal aid. It refers to enforcement of an ordinary legal aid. The High Court authorized for determining person authority and government of the civil jurisdiction. Territorial jurisdiction and the cause of action arises within its territorial jurisdiction. The jurisdiction of the High Court in Article 226 is not exclusive. When the jurisdiction of the Supreme Court, it means when the fundamental right for the region of a legislative party has the option of moving with the High Court, and the Supreme Court is clear whether the jurisdiction of the High Court is larger than that of the Supreme Court. Not for any other purpose, that it does not extend to a case where the breach is not legal right as challenged. The Chandra Kumar case, 1997, the Supreme Court that the jurisdiction of the High Court and the Supreme Court considered a part of the basic structure of the Constitution. In the Chandra Kumar case, 1997, the Chandra Kumar case 1997, the Supreme Court ruled that the jurisdiction of the High Court and the Supreme Court constitute a part of the basic structure of the Constitution and it cannot be ousted or excluded even by way of amendment to the Constitution. In Chandra Kumar case 1997, the Supreme Court ruled that the jurisdiction of the High Court and the Supreme Court constitute a part of the basic structure of the Constitution. The Chandra Kumar case 1997. In the Chandra Kumar case 1997, the Supreme Court ruled that the jurisdiction of the High Court and the Supreme Court constitute a part of the basic structure of the Constitution and it cannot be ousted or excluded even by way of an amendment to the Constitution. Chandra Kumar case 1997. Chandra Kumar case 1997 stated that Supreme Court ruled that the jurisdiction of the High Court and the Supreme Court constitute a part of the basic structure. The Constitution of the Supreme Court and High Court constitute a part of the basic structure of the Constitution, and hence it cannot be ousted or excluded even by way of an amendment to the Constitution. Next is the appellate jurisdiction. The High Court is primarily a court of appeal. Constitution and its territorial jurisdiction, it is civil jurisdiction in both civil and criminal cases, and the appellate jurisdiction of a High Court is wider than its original jurisdiction. Hence, the appellate jurisdiction of High Court is wider than its original jurisdiction. क्यों? क्योंकि वो both civil and criminal matters को deal कर सकता है, both civil and criminal matters. Hence, the appellate jurisdiction of High Court is wider than its original jurisdiction. Hence, the appellate jurisdiction of a High Court is wider than its original jurisdiction. Hence, the appellate jurisdiction of High Court is wider than its original jurisdiction. Civil matter, the civil appellate jurisdiction of High Court is as follows: for appeals from the order and judgment of the Judicial District Court and other subordinate court liability to the High Court and both the questions of land fact, the amount exceeds the stipulated limit. Second, appeal from the orders and judgment of the District Court or other subordinate court liability to the High Court in the cases involving questions of law only. यहाँ पे law and fact, questions of law only, but not questions of fact. The calculator में Madras High Court have provision for intra-court appeal. When a single judge of the High Court has decided a case under the original or appellate jurisdiction of High Court and appeal from such a decision as to the division bench of the same High Court. When a single judge of the High Court has decided a case either under the original or appellate jurisdiction of the High Court, appeals from the decision of the calculator movement Madras High Court have provision for intra-court appeal. The calculator movement Madras High Court have provision for intra-court appeal when a single judge of the High Court has decided a case the original appellate jurisdiction of the High Court and appeals from such a decision as to the division bench of the same High Court. When a single judge of the High Court has decided a case, when a single judge of the High Court has decided a case, either under the original or appellate jurisdiction of the High Court, appeal from such a decision as to the division bench, then it will lie to the division bench of the same High Court. If the decision is made by a single judge, so the High Court has decided a case either under the original or appellate jurisdiction of the High Court and appeal from such a decision as to the division bench of the same High Court. Appeals from the decision of the administrative and the tribunal lie to the division bench of the state High Court. Appeals from the decision of the administrative and the tribunal lie to the division bench of the state High Court. Appeals from the decision of the administrative and other tribunal lie to the division bench of the state High Court. Like to the division bench of the state High Court. In 1997, the Supreme Court ruled that the tribunal are subject to the jurisdiction of the High Court. Consequently, it is not possible for an executive to interpret the Supreme Court directly against the decision of the tribunal without first going to the High Court. Appeals from the decision of the administrative and other tribunal lie to the division bench of the state High Court. In 1997, the Supreme Court ruled that the tribunals are subject to the jurisdiction of the High Court. Tribunals are subject to the jurisdiction of the High Court. Criminal matters. The criminal appellate jurisdiction of the High Court is as follows: appeals from the judgment of Session Court and additional Session Court lie to the High Court if the sentence is one of imprisonment for more than 7 years. Appeals from the judgment of Session Court and additional Session Court lie to the High Court if the sentence is one of imprisonment for more than 7 years. If the sentence is one of the imprisonment for more than 7 years, it should be noted here that that sentence, popularly known as capital punishment awarded by Session Court or an additional Session Court, should be confirmed by the High Court before it can be executed. This sentence, which is also known as the capital punishment, awarded by a Session Court or an additional Session Court, should be confirmed by the High Court before it can be executed. It should be confirmed by High Court before it can be executed, whether there is an appeal by the convicted person or not. In some cases specified in various provision of the CPC, the appeals from the judgment of the Assistant Session Judge, Metropolitan Magistrate or other magistrates lie to the High Court. Supervisory jurisdiction. High Court has the power to execute sentence over all the courts in the middle functioning in its state or jurisdiction, except military courts or tribunals that check call for attention from them, make and issue general rules and prescribe forms for regulating the practice and proceedings of them, prescribe forms and rules and reason accounts to be kept by them, and settle the favor to the sheriff clerks officers and legal practitioners of them. This part of the attendance of the High Court is very broad because it is just very much broad because it extends to all courts and tribunals, whether they are subject to the appellate jurisdiction of the High Court or not. It extends to all courts and tribunals, whether they are subject to the appellate jurisdiction of the High Court or not. It covers not only administrative superintendents but also judicial superintendents. It covers not only administrative superintendents but judicial independence. It is a regional jurisdiction, it is a divisional jurisdiction, and it can be suo motu on its own, not necessarily on the application of party. It can be suo motu. However, this power does not vest the High Court with any unlimited authority over the subordinate court internally. It is an extraordinary power and hence is to be used more sparingly and only in appropriate cases. Usually it is limited to excess of jurisdiction, gross violation of natural justice, error of law, and is regard to the law of superior court, but who is finding a manifest injustice. Control over subordinate court in addition to superior jurisdiction and supervisory jurisdiction over the subordinate court, as mentioned above. A High Court has an administrative control of the powers over them. These include the following: that are consulted with the in the matter of appointment, posting, and promotion of districts. It is consulted by the governor in the matter of appointment, posting, and promotion of districts, and in the appointments of person to the judicial service of the state other than district judges. It deals with the matter of posting, promotion, grant of transfer, and discipline of the members of the judicial service of the state other than district judges. Matters of posting, promotion, it can be pending in subordinate court if it involves a substantial portion of law to require the interpretation of the constitution. It can then either dispose of the case interpreted with the question of law and return the case to the subordinate court with its judgment. Its law is binding on all subordinate court. Its law is binding on all subordinate courts functioning within its territorial jurisdiction. It seems since it's a law declared the Supreme Court is binding on all courts in India. The court is a court of the High Court has to further judgment proceeding and act with the High Court is a court for preaching the million testimony. These courts are admitted to be evidently when produced before any subordinate court. It cannot be questioned when produced before any subordinate court. There are recognized legal precedent, legal differences, which is a part of punishment for contempt of court, either with simple imprisonment or with fine of his body. Actually, contempt of court has not been defined in the Constitution. In the term that is the contempt of court has not been defined in the Constitution. Contempt of court not being defined by the Constitution. The expression has been defined with the Contempt of Court Act of 1921, and this contempt for both civilian and criminal. So they have been defined by the Constitution. The expression has been defined by the Contempt of Court Act of 1971. Defined by the Contempt of Court Act of 1971, and that is contempt of court may be civil, criminal, civil contempt, civil participation, civil judgment or directed with the process of a court of creature and undertaking given to a court criminal contempt the publication of any matter to be enacted scandalizes or lowers authority of a court. It scandalizes, lowers authority of a court, or prejudices or interferes with the due course of a judicial proceeding. It scandalizes or lowers the authority of a court, or prejudices or interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of some matter fair and accurate reported judicial proceeding fairly is never protested of judicial action commenced in the administrative side of the judiciary. No matter amount of contempt of court as a court or a High Court also has the power to review and correct its own judgment or other a decision, even though no specific power or review is conferred and by the Constitution. The Supreme Court and other and has been specifically the power of review by the Constitution. This is important. It is no specific power of review is conferred on it by the Constitution. No specific power of review is conferred on it by the Constitution. The Supreme Court, on the other hand, has been conferred with the power of review power of a High Court to examine the constitutionality of legislative enactment and executive order of both the central and state government on examination. If they are found to be violative of the constitution, that is otherwise they can be declared as illegal, unconstitutional, and null and void by the High Court. Consequently, they cannot be enforced by the government. Though the phrase judiciary has nowhere been used in the constitution, the provision of Article 13 and 226 judicial review has nowhere been used in the constitution. However, the phrase that is judicial review has nowhere been used in the constitution. Article 13 and Article 226 explicitly confer the power of judicial review on a High Court. The constitution violated of a legislative enactment or an executive order can be challenged in a High Court on the following three grounds. Grounds status. It infringes the FR, the constitutional validity of a legislative enactment or an executive order can be challenged in a High Court on the following three grounds. First, it infringes the FR. Part 3, it is outside the competence of the authority which has framed it and it is repugnant to the constitution. Provision, the 42nd Amendment Act of 1976 curtailed the judicial review power of High Court. It debarred the High Court from considering the constitutional validity of any central law. The 43rd Amendment Act of 1970 restored the original position. The 43rd Amendment Act of 1977. 42nd Amendment Act of 1976 curtailed the judicial review power of High Court. But this is important as 43rd Amendment Act of 1977 restored the original position. No specific power of review is conferred on the High Court, but in the case of the Supreme Court, it has been conferred with the power of review by the Constitution. Kerala, so the Kerala. Bombay, Maharashtra, Goa, Dadar, Nagar Haveli and Daman and Diu. Maharashtra, Goa, Dadar, Nagar Haveli and Daman and Diu. Maharashtra, Goa, Dadar and Nagar Haveli and Daman and Diu. Bombay, Maharashtra, Goa, Dadar, Nagar Haveli and Daman and Diu. Kolkata, West Bengal and Andaman and Nicobar Island. Guwahati, that is Assam, Nagaland, Mizoram, Arunachal Pradesh. Assam, Nagaland, Mizoram, Arunachal Pradesh. Nagaland, Mizoram, and Maharashtra Pradesh. Kerala, Lakshadweep, Kerala, Lakshadweep, Madhya Pradesh, and Chandigarh. 215 to 231. 214 to 231, 214 to 231. 15th Amendment Act of 1963. Next is the judiciary originated and developed in USA. Judiciary originated and developed in USA. The doctrine of judiciary originated and developed in the USA. The doctrine of judiciary originated and developed in the USA. It was propounded for the first time in the famous case of Marbury versus. It was propounded for the first time in the famous case of Marbury versus Medicine. Marbury versus Medicine, 1803, by John Marshall. It was propounded for the first time in the famous case of Marbury versus Medicine, 1803, by John Marshall, the then Chief Justice of the American Supreme Court. It was propounded first in the famous case of Marbury versus Medicine. Marbury versus Medicine by John Marshall, the then Chief Justice of the American Supreme Court. And on the other hand, the Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as High Court. Whether the Supreme Court has declared the power of judicial review the basic structure of the Constitution or an element of the basic structure of the Constitution. Hence, the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. Meaning of judicial review. Judicial review is the power of the judiciary to examine the constitutionality of legislative enactment and executive order over the central and state government. Judicial review is the power of the judiciary to examine the constitutionality of legislative enactment and executive order of the central and state government. On examination, if they are found to be violative of the constitution, they can be declared as illegal and unconstitutional and invalid, null and void by the judiciary. Consequently, they cannot be enforced by the government. Justice Syed Shah Mohammad Qadri has classified the judicial review into the following three categories: judicial review of constitutional amendment, judicial review of legislation of the parliament and state legislature and subordinate legislation, judicial review of administrative action of the union and state and authorities under the state. The Supreme Court uses the power of judicial review in various cases, as for example the Golaknath case, the bank nationalization case, the private parcel violation cases, the Keshwar and the Bharti case, the Minerva Mills case, and so on. In 2015, the Supreme Court declared both the 99 Constitutional Amendment 2014 and the National Judicial Appointment Commission (NJAC) Act 2014 as unconstitutional and null and void. The importance of judicial review. Judicial review is needed for the following reason. Judicial review is needed for the following reason: to uphold the principle of the supremacy of the Constitution, to maintain federal equilibrium. Judicial review is needed for the following reason: to uphold the principle of the supremacy of the Constitution, to maintain federal equilibrium in balance between center and the state, to protect the power of the citizen. In a number of cases, the Supreme Court has pointed out the significance of the power of judicial review in the country. Some of the observation made by it in this regard is given below. Namely, it is a constitution that the Supreme Court has statute to be valid must be in conformity with the Constitution. That it is for the judiciary to decide whether an enactment is constitutional or not. Our Constitution contains express provision for judicial review of legislation as to its conformity with the Constitution. This is especially true as regards the fundamental right to which the court has been assigned the role of sentinel on the quo vive. As long as some FR exists in a part of the Constitution, the power of judicial review has also to exercise the view to see that guarantees afforded by these rights are not contravened. The Constitution is supreme lex and permanent law of the land, and there is no branch of government above it. Every organ of government, be it the executive, the legislature, or the judiciary, provides its authority from the Constitution, and it has to act within the limits of its authority. No one, however highly placed in authority or howsoever lawfully, can claim that it shall be the sole judge of the extent of its power under the Constitution, or whether its action is within the confines of such power laid down by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what is the limit, and whether any action or branch transgresses such limit. It is essential that the judges may their duty to pronounce upon the validity of law. The courts are totally deprived of that power. The fundamental right conferred on the people will become a mere adornment, because rights without remedies are as written water. A controlled constitution will then become uncontrolled. The judges of the Supreme Court have been entrusted with the task of upholding the Constitution, and thus and have been conferred the power to interpret it. That is, they ought to ensure that the balance of power in which has with the Constitution is do not let the charge of the country transgress constitutional limitation. The founding fathers very wisely therefore incorporated in the Constitution itself the provision of judicial review so as to maintain the balance of federalism, to protect the apparent fundamental freedom guaranteed to the citizen, and to afford a useful weapon for availability, availment, and enjoyment, equality, liberty, and fundamental freedom, and to help create nationalism. The function of judicial review is part of the constitutional interpretation itself. It edges the Constitution to meet new conditions and meets at the time constitutional provisions for judicial review, though given judicial review has nowhere been used in the Constitution. The provision of several articles explicitly confer the power of judicial review on the Supreme Court and the High Court. These provisions are explained below. Article 13 declares that all the laws that are inconsistent with or in derogation of the FR shall be null and void. It states that all the laws that are inconsistent all the laws that are inconsistent with or in derogation of the FR or in derogation of the FR. Article 13 declares that all laws that are inconsistent with or in derogation of the FR shall be null and void. Article 13 declares that all laws that are inconsistent with or in derogation of the FR shall be null and void. Article 13 declares that all laws that are inconsistent with or in derogation of the FR shall be null and void. Article 32 guarantees the right to move the Supreme Court for the enforcement of the FR and empowers the Supreme Court to issue directions on orders of its for that purpose. Article 32 guarantees the right to move the Supreme Court for the enforcement of the FR and empowers the Supreme Court to issue directions constitutions or orders or rules for that purpose. Article 131 provides for the original jurisdiction of the Supreme Court. Article 144 to 147. So Article 131 provides for the original jurisdiction of the Supreme Court as interstate and interstate dispute. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. Article 132 provides for the appellate jurisdiction of the Supreme Court in the constitutional cases. 132 provides for the appellate jurisdiction in the case of the in civil cases. यहाँ पे in constitutional cases, in civil cases, and provide for the appellate jurisdiction of the Supreme Court in criminal cases. Constitutional, civil, and then criminal. Constitutional, civil, and then criminal. 131 original, 132 constitutional cases, appellate jurisdiction. 133 appellate jurisdiction in civil cases, and 134 appellate jurisdiction in criminal cases. Article 134 it deals with the certificate for appeal to the Supreme Court from High Court. For appeal to the Supreme Court from the High Court. For appeal to the Supreme Court from High Court. For appeal to the Supreme Court from the High Court, and this was added by 44th Constitution Amendment Act of 1978. Added by the 44th Constitutional Amendment Act. It was added by the 44th Constitutional Amendment Act of 1978. It was added by the 44th Constitutional Amendment Act of 1978 that the cases from High Court are to be appealed to the Supreme Court. Is with the certificate for appeal to the Supreme Court from the High Court. Article 135 empowers the Supreme Court to exercise its jurisdiction and powers of federal court under any pre-constitutional law. Powers of the federal court. Powers to exercise jurisdiction and powers of federal court under any pre-constitutional law. 1. Authorizes the Supreme Court to grant special leave to appeal from any court or tribunal. Authorizes the Supreme Court to grant special leave to appeal from any court or tribunal except military tribunal or political. 143 authorizes the President to seek opinion of the Supreme Court on any question, law or fact on any pre-constitutional legal matter. Article 226. That is binding and otherwise is not binding. It is must and hence it is not binding. It is not binding on the Constitution, but in the case of pre-constitution treaties are expected. The Supreme Court have to give its opinion, but in the cases of law or fact, it may or may not or refuse to give opinion. Article 226 empowers the High Court to issue directions and orders and rules for the enforcement of the FR for the purpose. Article 226, Article 226 empowers the High Court to issue directions and orders and rules for the enforcement of the FR and for the purpose. Next is Article 227 vests in the High Court the power of superintendence over all the courts and tribunals within their respective territorial jurisdiction except military court or tribunal. Article 227. In the High Court, the power of superintendence over all the courts and tribunals within respected. Article 227 vests in the High Court the power of superintendence over all courts and tribunals within their respective territorial jurisdiction except military court or tribunal. Article 245. Article 231 from where? authority appointed what is the state of the public matter clause made by Parliament with the legislature decided is evenly stateless and concurrent list. The constitutional authority of a legislative enactment or an executive order can be challenged in the Supreme Court and in the High Court on the following three grounds. Therefore, it is outside the competence of the authority which is rendered. It is repugnant to the constitutional provision of the office that judicial review in India is narrower than what exists in the US. Although the American Constitution does not explicitly mention the concept of judicial review in any of its provisions. This is because the American Constitution provides for due process of law against startup procedure established by law which is contained in the Indian Constitution. The difference between the due process of law gives rise to grant protection to the rights of the citizen. It can declare law violator of these rights void not only on substantive ground of being unlawful but also on procedural ground of being unreasonable. Our Supreme Court, while determining the constitutionality of a law, however, examines only the substantive question that whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of its reasonableness, suitability, or policy implications. Judicial review. The power of judicial review in India is narrower. In India is narrower than that what exists in the USA. There is a wide power of judicial review by the American Supreme Court in the name of due process of law. It was thus been the pretext to describe it as a third American legislature, super legislature, the arbiter of social policy, and so on. This American principle of judicial supremacy is also recognized in our constitution system, but to a limited extent. Not to be fully follow the British principle of parliamentary supremacy, there are many limitations on the sovereignty of parliament in our constitution. There are many limitations on the sovereignty of parliament in our constitution, in our country. Like written character of the constitution, the federal division of power, the fundamental right, and the judicial review. In effect, what exists in India is a synthesis of both. That is, American principle of judicial supremacy and the British principle of parliamentary supremacy. Judicial review of the ninth schedule. Judicial review of the ninth schedule. Article 31 says the acts and regulations included in the ninth schedule to being challenged. Article 31 says the acts and regulations included in the ninth schedule to being challenged and invalidated on the ground of contravention of any of therefore. Article 31B along with the ninth schedule was added by the Article 31B along with the ninth schedule was added by the first Constitutional Amendment Act of 1951. In December 1941, ninth schedule contained only 13 acts and regulations, but at present their number is 282. All these acts and regulations of the state legislature deal with land reforms and abolition of the Mandai system and that of the parliament deal with other matters. However, in a significant judgment delivered in Iyer Kolia case, the Supreme Court ruled that there could not be any blanket immunity from judicial for the laws included in the ninth schedule. The court held that judicial was a basic feature of the constitution and it could not be taken away for putting a law under the ninth schedule. Iyer Kolia case in 2007, it said laws placed under the ninth schedule after April 24, 1973 are open to challenge in court if they violate FR guarantee under the Article 14, 15, 19 and 21. And the basic structure of the constitution, it was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic feature of the constitution and its landmark verdict in the case when the Bharti case filed during the whole judgment. The Supreme Court made the following conclusion: a law that hypocrites are a religious right guaranteed by Part 3 of the constitution may violate the basic structure of it or may not if formed as a consequence of law with by an amendment of an article of Part 3 or by an insertion in the ninth schedule. Such law will have to be invalidated in the exercise of judicial review by the court. The constitutional validity of the ninth schedule laws in the touchstone of basic structure doctrine can be assessed by applying the direct impact and effect as that is right test. One with a determinative factor. A law that abrogates or abrogates right guaranteed by Part 3 of the Constitution may violate the basic structure doctrine or it may not if formed as a consequence. By an amendment of any article of Part 3 or by an insertion in the ninth schedule, such law will have to be validated in the exercise of judicial power of the court. The constitutional validity of ninth schedule laws on the touchstone of basic structure doctrine can be adjusted by applying the direct impact and effect as that is rights test. Can be adjusted by applying the direct impact and effect as that is right test, which means a form of an amendment is not the relevant factor but the consequence thereof but with the determinative factor. the majority judgment in the case and the Bharti case and reduced in Gandhi case 1975 requires the validity of each new constitutional amendment to be judged on its own merit, the actual effect and impact of the law on the right can integrate and the part that has to be taken into account for determining whether or not industrial basic structure the impact test would determine the validity of the challenge. All amendment to the constitution made on or after 24 April 1973 by which the 9th schedule is amended by no various laws therein shall have to be rested on the touchstone of the basic or essential feature of the constitution as protected in Article 21 with Article 14 and 19 and the principle underline them. To put it differently, even though an act is put in the 9th schedule by constitutional amendment, provision would be open to attack on the ground that the rest of them as a basic structure. If the FRO rights taken over implicated pertains or pertain to the basic structure, justification for conferring protection not blanket protection on the laws included in the 9th schedule for constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute ought to be constitutionally protected and on the touchstone of the basic structure of the Article 21 with Article 14 18 by application of the rights test and the essence of the right test, taking the synoptic view of the article in part 3rd as held in the Indira Gandhi case. Justification for conferring protection not blanket protection on the laws included in 9th schedule with the constitutional amendment shall be a matter of constitutional adjudication and examine the nature and extent of infraction of the FOI by a statute so to be constitutionally protected and on the touchstone of the basic social documents as reflected in Article 21 to Article 14 18 by application of the right test and the essence of the right test taking synoptic view of the article in part 3rd as held in the Indira Gandhi case 16. Applying the above test to the 9th schedule laws if the infraction affects the basic structure infraction of the basic structures and such a law or laws will not get the protection of 9th schedule and the triangle of Article 21 read with Article 14 and Article 19 are sought to be eliminated. Not only the essence of the right test but also the right test has to apply. There is also a difference between the right test and the essence of the right test both for part of application of the basic structure doctrine when in a controlled situation conferring limited power of amendment and attached after is made inapplicable. The essence of the right test is applied in Nagaraj case will have no applicability in such a situation to judge the validity of law. It is the right test which is more appropriate. When in a controlled constitution conferring limited power of amendment, an entire chapter is made applicable. The essence of the right test is applied in Nagaraj case will have no applicability. In such a situation to judge the validity of law, it is the right test. If the validity of any 9th schedule law has already been upheld by this court, it will not be open to challenge such law again. If the validity of any 9th schedule law has already been upheld in the court, it would not be open to challenge such a law again on the principle declared by this judgment. However, if a law held to be valid of any of therefore in part the order incorporated in 9th schedule after 25 April 1973, such a violation infraction will be open to challenge on the ground that it destroys or damages the basic structure as indicated in Article 21 with Article 14 and 19. Included before 24 April 1973, First Amendment, 7th Amendment and 29th Amendment. Included after April 24, that is 34th Amendment, 39th Amendment, 40th Amendment, 47, 66, 76 and 78th Amendment Act, 87, 91, 30 have been omitted by the 44th Amendment Act of 1978. Marbury versus Madison case in 1803 by John Marshall, Chief Justice. Judicial dynamism, judicial activism. The concept of judicial activism originated and developed in the USA. This term was first coined in 1947 by Arthur Schlesinger Jr. Arthur Schlesinger Jr. Arthur Schlesinger Jr. This term was first coined in 1947. This term was first coined in 1947 by Arthur Schlesinger Jr. First coined in 1947 by Arthur Schlesinger Jr., an American historian and educator. The concept of judicial activism originated and developed in the USA. This term was first coined in 1947. The concept of judicial activism originated and developed in the USA. This term was first coined in 1947 by Arthur Schlesinger Jr., an American historian and educator. In India, the doctrine of judicial activism was introduced in the mid-1970s. In India, the doctrine of judicial activism was introduced in the mid-1970s. Developed in the US in 1947 by Arthur Schlesinger Jr., an American historian and educator. In India, the doctrine of judicial activism was introduced in the mid-1970s. Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice Ochana Pareddy, and Justice D. Desai laid the foundation of judicial activism in the country. Introduced in the mid-1970s, it was introduced in the mid-1970s. Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice Ochana Pareddy, and Justice D. Desai laid the foundation of judicial activism in the country. Meaning of judicial activism. Judicial activism denotes the proactive and role played by the judiciary in the protection of the right of citizens and promotion of justice in the society. In other words, it implies the assertive judicial activism can be defined as a process taken by the other means an act of interpretation of existing legislation by a judge. and the executive failed to protect the basic right of education, like the right to live or reason, like this not to cover the honest, efficient system of laws and administration. And the quota clause is misused by a strong authoritarian parliamentary party government for a where the court of law is misused by a strong authoritarian parliamentary party government. judgment and politics being concerned only with the power and influence. Law being the process of reason and judgment and politics being concerned only with the power and information. It is clear that all the assumption etc. in dealing with the judicial use in the Indian context. It's very good observations. Not to take over the fundamental of the executive frame is about separation of power under the constitution. Each organ the state must have respect for others. I'm taking a 5-minute break. public interest litigation. The concept of PIL originated and developed in the US in 1960s. In the US, it was designed to provide legal representation to I will answer all your queries at the end of the session. 2 या 2.5 आवर्स का सेशन होगा, उसके बाद मैं आंसर करूँगी. Krishna and Justice P. and Bhavati are the pioneers of the concept of PIL. In India, PIL is a product of judicial activism known as the Supreme Court. It was introduced early in the early 1980s. Justice V. R. Krishna and Justice P. and Bhavati concept of PIL. Justice V. R. Krishna and Justice P. and Bhavati are the pioneers of the concept of PIL. It is also known as SAL, that is social action litigation, social interest litigation, and class action litigation. 47, Part 6 of the Constitution. The state judiciary consists of a high court and a hierarchy of subordinate court, also known as lower court. The subordinate court are also called because of their subordination to the state high court. The function below and under the high court and district and lower level constitution provision Article 233 to 237. And Part 6 of the Constitution with the following provision to regulate the organization of subordinate court and to ensure their independence from the executive. Appointment of district judges 233. The appointment, posting and promotion of district judges in state are made by the governor of the state in consultation with the high court. Okay, so it is made by the governor of the state in consultation with the high court and consultation with the state high court. A person to be appointed as a district judge should have the following qualification. He should not already be in the service of the central or the state government. He should not already be in the service of the central or the state government. He should be an advocate for a period of 7 years. Should have been a judge of a high court. He should have been a judge of a high court for 5 years. He should have been a judge of high court for 5 years. He should have been an advocate of a high court for 10 years, and he should be a distinguished jurist. And in the case of held on judicial office in the territory of India for 10 years, he should have been an advocate of a high court for 10 years. Advocate of a high court for 10 years, common, held a judicial office in the territory of India for 10 years, and distinguished jurist on it. He should have been an advocate or a pleader for 7 years. He should be an advocate or a pleader for 7 years. 7 years. He should be recommended by the High Court for appointment. He should be recommended by the High Court. He should be recommended by the High Court. He should be recommended by the High Court for appointment. He should not already be in the service of the central or the state government. He should not already be in the service of the central or the state government. He should have been an advocate or a pleader for 7 years. He should not already be in the service of the central or the state government. He should not be in the service of the central or the state government. He should be a pleader or an advocate for 7 years. For 7 years, he should have been an advocate or pleader for 7 years. He should be recommended by the High Court for appointment. He should be recommended by the High Court for appointment. He should be recommended by the High Court. He should be recommended by the High Court for appointment. He should be recommended by the High Court for appointment. He should be recommended by the High Court for appointment. He should be recommended by the High Court. He should be recommended by the High Court for appointment. He should be recommended by the High Court for appointment. So first is that he should not be employed in the central or state government service. He must be an advocate or pleader for 7 years. And third is he should be recommended by the High Court for appointment. Appointment of other judges. Appointment of person other than the district judges to the judicial office in the state are made by the governor of the state after consultation with the State Public Service Commission and the High Court. Here two people will play the role in the appointment of district judges, governor of the state in consultation with the state high court, in consultation with the high court, in consultation with the high court, in consultation with the high court. Governor of the state in consultation with the high court at the appointment of district judges. In the case of appointment of other judges, governor of the state are made by the governor of the state and made by the governor of the state after consultation with the State Public Service Commission and the High Court after consultation with the State Public Service and the High Court. Secretary of the State Public Service Commission conducts a comparative examination for the improvement of the judicial service of the state. Okay, so governor, State Public Service Commission and the High Court control over subordinate court, the control over district court and other subordinate court, including the post and promotion leave of person belonging to the judicial service of a state and holding in the posting period of the post of district judges vested in the High Court. District judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, session judge, additional session judge, and assistant session judge. The expression judicial service means a service consisting exclusively of person intended to fill the post of district judge and other civil and judicial posting period of the post of district judge. The expression judicial service means a service consisting exclusively of person post of district judge. ठीक है. Application of the above provision to certain legislative government agencies. The above mentioned provisions relating to person, the state judicial service would apply to any class or classes of magistrate in the state, and who has the power to do that, that is the governor. Civil and criminal code. Broadly speaking, there are three tiers of civil and criminal code. There are three tiers of civil and criminal code below the High Court. There are broadly speaking, there are three tiers of civil and criminal code below the High Court. Broadly speaking, there are three tiers of civil and criminal codes below the High Court. This is shown as follows: High Court. Below it comes the district and session judge court. District court is for civil cases, and session judges court is for criminal cases. Civil side and criminal side. Civil side, subordinate judge court, and it is headed by subordinate judges court and municipal court. इसको हम लोग civil judge भी बोलते हैं. Criminal side, chief judicial magistrate court, judicial magistrate court. The district judge is the highest judicial authority in the district. The district judge is the highest judicial authority in the district. He possesses regional and appellate jurisdiction in both civil as well as criminal matter. In other words, the district judge is also the session judge when he deals with civil cases. When he deals with civil cases, he is known as a district judge, and when he hears the criminal cases, he is called the session judge. The district judge exercises both judicial and administrative power. He also supervises the powers of all the subordinate court and appeals against his orders and judgment lie to the High Court, and appeals against his orders and judgment lies to the High Court directly. The session judge has the power to impose any sentence including life imprisonment and capital punishment, that is death punishment. However, capital punishment passed by him is subject to confirmation by the High Court whether there is an appeal or not, and this is an important point. That is, capital punishment passed by him is subject to confirmation by the High Court whether there is an appeal or not. Whether the district and session court stands a court of subordinate judge on civil side, court subordinate judge court, and the court of chief judicial magistrate. Civil side के नीचे आता है subordinate judge court, और इसमें आता है chief judicial magistrate court. The subordinate judge exercises unlimited pecuniary jurisdiction over civil suit. The chief judicial magistrate decides criminal cases which are punishable with imprisonment for a term up to 7 years, and chief judicial magistrate court decide criminal cases. Chief judicial magistrate court decide criminal cases which are punishable with imprisonment for a term up to 7 years. For a term up to 7 years. At the lowest level on the civil side is the court of municipal, and on the criminal side is the court of judicial magistrate. Chief judicial magistrate court and judicial magistrate court. Criminal side में session judge हो गया, फिर chief judicial magistrate court हो गया, and judicial magistrate court हो गया. Chief judicial magistrate court can give an imprisonment of up to 7 years. Okay. The municipal possesses limited jurisdiction and decides civil cases of small pecuniary state. The municipal possesses limited jurisdiction and decides civil cases of small pecuniary state. Civil judge, classic and so on. Municipal is also known as civil judge. The judicial magistrate tries criminal cases which are punishable with imprisonment for a term up to 3 years. Okay, in some metropolitan cities there are city civil courts, chief judges on the civil side. कुछ metropolitan cities में there are city civil courts on the civil side and the court of metropolitan magistrate on the criminal side. City civil courts होते हैं कुछ metropolitan जगह पे. There are chief judges on the civil side and the court of metropolitan magistrate on the criminal side. Some of the states and presidential towns have established small causes court. These court decide the civil cases of small value in a summary manner. The decision are final, but the High Court possesses the power of revision. Delhi, Bombay, Calcutta, Madras were formerly called presidency towns. Okay. In some states, panchayat petty civil and criminal cases they are variously known as Nyaya Panchayat. कुछ states में panchayat court होता है petty civil and criminal cases को देखते they are variously known as Nyaya Panchayat, Gram Kacheri, Adalati Panchayat, Panchayat Adalat, and so on. 233, 33A, 34, 35, 36, 37. National Legal Services Authority. National Legal Services Authority, Article 59. Article 39 of the Constitution of India provides for free legal aid to the poor. Article 39 of the Constitution of India provides for free legal aid to the poor and weaker section of the society. Article 39 of the Constitution of India provides for free legal aid to the poor and weaker section of the society. Article 39A. Article 39A of the Constitution of India provides for free legal aid to the poor and weaker section of the society and ensures justice for all. Article 14 and 22(1) of the Constitution also makes it obligatory. Article 22(1). The Legal Services Authority Act was enacted by the Parliament in the year 1987. The Services Authority Act was enacted by the Parliament in 1987. The Legal Services Authority Act was enacted by the Parliament, which came into force on 9th of November, which came into force on 9th of November 1995. Came into force on 9th of November 1995 to establish a nationwide limit for providing free and competent legal service to the weaker section of the society on the basis of equal opportunity. The National Legal Service Authority has been constituted under the Legal Services Authority Act 1987, that is NALSA, National Legal Services Authority. The National Legal Services Authority has been constituted under the Legal Services Authority Act 1987 to monitor and evaluate implementation of legal aid programs and to lay down the policies and principles for making legal services available under the Act. In every state, a state legal service authority, and in every high court, a high court legal services committee have been constituted. The district level services authorities, taluk level service committee have been constituted in the district and most of the talukas to give to the policies and direction of the NALSA and to provide free legal services to the people and conduct local adalat in the state. The Supreme Court Legal Service Committee has been constituted to administer and implement the legal service program insofar as it relates to the Supreme Court of India. The NALSA lays down policies, principal guidelines and frames effective and economical scheme for the state legal service authority to implement the legal service program throughout the country. Primarily, the State Legal Service Authority, District Level Legal Services Authority, Taluk Level Service Committee, etc. have been asked to discuss the following mentioned on a regular basis to provide free and competent legal service to the eligible person, to organize Lok Adalat for amicable settlement of dispute, to organize legal awareness camp in the rural area. The free legal services include payment of court fee, process fee, and all other charge payable or incurred in connection with any legal proceeding, providing services lawyer and legal proceeding, obtaining and supply of certified copies of audit and documented legal proceedings. The persons eligible for getting free legal services include women, children, members of SC/ST, industrial government, victim of mass disaster, violence, flood, drought, earthquake, industrial disaster, disabled person in custody, person whose annual income does not exceed 1 lakh. In the Supreme Court Legal Service Committee, the limit is 1,25,000. Victims of trafficking in human being or Begar Lok Adalat. The Lok Adalat is a forum where the cases of dispute which are pending in a court or which are at pre-litigation stage, not yet compromised or settled in an amicable manner. The Supreme Court has explained the meaning of the institution of Lok Adalat and the following with the Lok Adalat is an old form of adjudicating system prevailed in ancient India and its validity has not been taken away even in the modern days. To the word Lok Adalat means people's court. The system is based on Gandhian principle. It is one of the components of ADR, that is alternate dispute resolution system. As Indian courts are overburdened with backlog of cases on the regular court decide the cases involving a lengthy, expensive and tedious procedure. The court takes years together to settle with petty cases. The Lok Adalat therefore provides an alternative resolution and device for expeditious and inexpensive justice. The Lok Adalat therefore provides alternative resolution or device for expeditious and inexpensive justice. In Lok Adalat proceeding, there are no victors in vanquish and there is no rancor. The experiment of Lok Adalat as an alternate mode of dispute resolution has come to be accepted in India as a viable, economic, efficient and informal one. Lok Adalat is another alternative and judicial justice. This is a recent strategy for delivering informal, cheap and expeditious justice to the common man by way of settling disputes which are in court and also those which have not yet reached court by negotiation, conciliation, by adopting persuasive common sense and human approach to the problems of the disputants with assistance of specially trained and experienced members of a team of conciliators. Statutory status. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1992. The very first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. It was organized in Gujarat in 1982. It was organized in Gujarat in 1982. This initiative proved very successful in the settlement of dispute. Consequently, the institution of Lok Adalat started spreading to other parts of the country. At that time, this institution was functioning as a voluntary and conciliatory agency without any strategic backing for its decision. This institution and awards given by Lok Adalat, the institution of Lok Adalat has been given statutory status under the Legal Services Authority Act of 1987. इसको मिलेगा statutory status under the Legal Services Authorities Act of 1987. The act with the following provision relating to the organization and functioning of Lok Adalat, the State Legal Services Authority, the State Legal Service Authority, or the Supreme Court Legal Services Committee, or the High Court Legal Service Committee, or the Trial of Legal Service Committee may organize Lok Adalat at such interval and places and for exercising such jurisdiction and for such areas. It thinks that every Lok Adalat organized by an area shall consist of the number of serving or retired judicial officers and other persons of the areas will be specified by the agency organizing such Lok Adalat. Generally, a Lok Adalat consists of a judicial officer as the chairman. Generally, a Lok Adalat consists of a judicial officer as the chairman and a lawyer, advocate and a social worker as member. तीन लोग होते हैं, a judicial officer as a chairman and a lawyer, that is advocate and a social worker as member. Lok Adalat shall have given jurisdiction to determine and arrive at the compromise or settlement between the parties to a dispute in respect of any case pending before any court. Any matter which is falling within the jurisdiction of any court and is not brought before such court. Thus, the Lok Adalat can deal with not only the cases pending before a court but also with the dispute at pre-litigation stage. Lok Adalat can deal with not only the cases pending before a court but also with the dispute at pre-litigation stage. The various matters such as matrimonial, family dispute, criminal offences cases, land acquisition cases, labor dispute, workman compensation cases, bank recovery cases, pension cases, housing board and slum clearance cases, housing finance cases, consumer grievance cases, electricity matters, dispute relating to telephone bills, municipal matters including house cases, dispute with cellular companies, etc. are being taken up in Lok Adalat. But the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. The Lok Adalat shall have no jurisdiction, but the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. But the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. In other words, the offences which are non-compoundable under any law fall outside the purview of the Lok Adalat. Lok Adalat shall have the same power as are vested in the civil court under the Code of Civil Procedure 1908. The Lok Adalat shall have the same power vested in the civil court under the Code of Civil Procedure while trying a suit in respect of the following matter: the summoning and enforcing the attendance of any witness, examining him or not, the discovery and production of any document, the reception of evidence on affidavits, the requisitioning of any public report document from any court or office. While trying a suit in respect of the following matter, the Lok Adalat shall have the same power as a vested in the civil court under the Code of Civil Procedure 1908. The Lok Adalat shall have the same power as a vested in the civil court under the Code of Civil Procedure. The Lok Adalat shall have the same power as a vested in the civil court under the Code of Civil Procedure. The Lok Adalat shall have the same power as vested in the civil court under the Code of Civil Procedure 1908 when trying a suit in respect of the following matter: the summoning and enforcing the attendance of any witness, examining him on oath, discovery and production of any document, the reception of evidence on affidavit, the requisitioning of any public record document from any court or office. Civil Court under the Code of Civil Procedure 1908, such other matters as may be prescribed. Further, a Lok Adalat shall have the requisite power to specify its own procedure for the determination of any dispute arising before it. Also, all proceeding before a Lok Adalat shall be deemed to be judicial proceeding within the meaning of Indian Penal Code, and every Lok Adalat shall be deemed to be a civil court for the purpose of the Code of Criminal Procedure. 1973, an award of a Lok Adalat shall be deemed to be declared for a civil court or an order. An award of a Lok Adalat shall be deemed to be a decree of a civil court or an order of any other court. Every award made by Lok Adalat shall be final and binding on all the parties. Every award made by Lok Adalat shall be final and it is also binding on the parties to the dispute. No appeal shall lie to any court against the award of the Lok Adalat. No appeal shall lie to any court. No appeal shall lie to any court against the award of the Lok Adalat. Against the award of the Lok Adalat. No appeal shall lie to any court against the award of the Lok Adalat. No appeal shall lie to any court against the award of the Lok Adalat. Must give benefit according to the Supreme Court. The benefit in the Lok Adalat as follows. There is no court fee, and if the court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat. The basic features of Lok Adalat are the procedural flexibility and speedy trial. Procedural flexibility of the speedy trial on the dispute, there is no strict application of procedural laws like the Civil Procedure Code and Evidence Act. While assessing by Lok Adalat, the parties of dispute can directly interact with the judge. So their counsel, which is not possible in regular courts, but the award by the Lok Adalat is binding on the parties and it has the status of a decree of a civil court. जो award है by the Lok Adalat is binding on the parties and it is non-appealable, which does not cause a delay in the settlement of dispute. Finally, in view of above facilities provided by the Act, Lok Adalat are boon to the litigating public that they can get to the fast and free of cost immediately. The Law Commission of India summarized the advantage of alternative dispute resolution in the following ways. It is less expensive, less time consuming, it is free from technicalities, vis-a-vis conducting of cases in law courts. Parties are free to discuss their differences of opinion without any fear of disclosure before any law court. Parties have the feeling that there is no losing or winning side between them, but at the same time, their agreements is redressed and their relationship is reached within Lok Adalat. The Legal Service Authority Act of 1987 was amended in 2002 to provide for the establishment of the permanent Lok Adalat to deal with cases pertaining to the public utility services. 2002 to provide for the establishment of the permanent Lok Adalats. The first Lok Adalat camp was organized in Gujarat in 1992. The first Lok Adalat camp was organized in Gujarat in 1982. And institution of Lok Adalat has been given statutory status under the Legal Services Authorities Act of 1987. The first Lok Adalat campaign was organized in Gujarat in 1982. In Gujarat in 1982. The reasons for the establishment of permanent Lok Adalat are as follows. The Legal Service Authority Act 1987 was enacted to constitute Legal Service Authority for providing free and competent legal service to the weaker section of the society to ensure that the opportunity peaceful security justice without denied to any reason of economic or other level disabilities, and to organize Lok Adalat to ensure that the operation of the legal system promotes justice on a basis of equal opportunity. The system of Lok Adalat, which is an innovative mechanism for alternative dispute resolution, has proved effective for resolving dispute and has spread of conciliation also to the court. The major drawback in the existing scheme of organization of the Lok Adalat under the Act is that the scheme of organization is mainly based on compromise settlement between the party. If the parties do not arrive at any compromise or settlement, the case is either returned to the court of law or the parties are advised to seek remedy in the court of law. Okay, this causes unnecessary delay in the dispensation of justice. If Lok Adalat given power to decide the case of merit and case parties fails to arrive at any compromise or settlement, the problem can be tackled to a great extent. Further, this problem can be tackled to a great extent. Further, the cases which arise in relation to public utility services such as Mahanagar, Telephone Nagar Limited, Delhi Video Board, etc. need to be settled urgently so that people get justice without delay even at pre-litigation stage, and most of the petty cases which are not hold up in the regular court would be settled at the which arise in relation to public utility services such as Mahanagar, Telephone Nagar Limited, Delhi Vidyut Board, etc. need to be settled urgently so that people get justice without delay even at pre-litigation stage, and thus most of the petty cases which ought not to go in the regular court will be settled at the pre-litigation stage itself, which will result in reducing the workload of the regular court to a great extent. Next is it is therefore proposed to amend the Legal Service Authority of 1987 to set up permanent Lok Adalat for providing compulsory pre-litigative mechanism for conciliation and settlement of cases relating to public utility services. Features. The second features of the new institution of permanent Lok Adalat as follows. A permanent Lok Adalat shall consist or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge and two other persons having adequate experience in public utility services. We are talking about the permanent Lok Adalat, and permanent Lok Adalat shall consist of a chairman who is or has been a district judge or an additional district judge or has held judicial office higher in rank than that of the district judge and two other persons having adequate experience in public utility services. The permanent Lok Adalat shall exercise jurisdiction in respect of one or more public utility services such as transport service of passengers or goods by air, road and water, postal, telecommunication, phone service, supply of power, light or water to the public by any establishment, public conservancy or sanitation services in hospitals or dispensaries and insurance services. The pecuniary jurisdiction of the permanent Lok Adalat shall be up to Rs 10 lakh. The pecuniary jurisdiction of the permanent Lok Adalat shall be up to Rs 10 lakhs. However, the central government may increase the said pecuniary. However, the central government may increase the said pecuniary jurisdiction from time to time. The permanent Lok Adalat shall have no jurisdiction in respect of any matter relating to an offence not compoundable under any law. Before this dispute is brought before any court, any party to the dispute may make an application to the permanent Lok Adalat for settlement of the dispute. After an application is made to the permanent Lok Adalat, no party to that application shall invoke the jurisdiction of any court in the same dispute. Where it appeals to the permanent Lok Adalat that there exist elements of settlement in terms of possible settlement and submit them to the parties for the observation, and in case of the parties reach an agreement, the permanent Lok Adalat shall pass an warrant on thereof. In case parties to the dispute fail to reach an agreement, the permanent Lok Adalat shall decide the dispute on merits. In case the parties to the dispute fail to reach an agreement, the permanent Lok Adalat shall decide the dispute on merits. Every award made by the permanent Lok Adalat shall be final and binding. Every award made by the permanent Lok Adalat shall be final and binding on the all parties at one shall be by majority of the person constituting the permanent Lok Adalat. Every award made by the permanent Lok Adalat shall be final and binding on all the parties at one shall be by a majority of the person constituting the permanent Lok Adalat. Every award made by the permanent Lok Adalat shall be final and binding on all the parties at one shall be by a majority of the person constituting the permanent Lok Adalat. The Family Courts. The Family Courts Act 1984 was enacted to provide for the establishment of family courts. The Family Courts Act 1984 was enacted to provide for the establishment of family court with a view to promote conciliation and suppose speedy settlement of disputes relating to marriage and family affairs. The reason for the establishment of separate family courts are as follows. Family Court Act 1984 features the establishment of family court by the state government in consultation with the High Court. Established they are to be established by the state government in consultation with the High Court. They are to establish with the state government in consultation with the High Court. Family courts, they are to be established by the state government in consultation with establishment, the family code, establishment of family code by the state government in consultation with the High Court. It makes it obligated on the state government to set up a family code in every city or town with a population exceeding 1 million. It is obligatory on the state government to set up a family code in every city or town with a population exceeding 1 million. It enables the state government to set up family code in other area also if they deem it necessary. It enables the state government to set up family code in other area also. It it enables the state government to set up family code in other areas also if they deem it necessary. It exclusively provides within the jurisdiction of the family code the matter relating to makes it obligatory on the part of the family code to endure only one right of appeal which shall lie to the right of appeal which shall lie to the High Court. Only one right of appeal, only one right of appeal which shall lie to the High Court. It provides for only one right of appeal which shall lie to the High Court. It provides for only one right of appeal which shall lie to the High Court. Gram Nyayalaya Act of 2008. Gram Nyayalaya Act of 2008 has been enacted for the establishment of Gram Nyayalaya at the grassroots level. The salient features of the Gram Nyayalayas Act are as follows. The Gram Nyayalaya shall be the court of judicial magistrate of first class. The officer Nyayadhikari shall be appointed with the state government in consultation with the High Court. The Gram Nyayalaya shall be court of judicial magistrate of the first class. The Gram Nyayalaya shall be court of the judicial magistrate. The Gram Nyayalaya shall be court of judicial magistrate of the first class. The Gram Nyayalaya shall be the Gram Nyayalaya shall be the court of judicial magistrate of first and its presiding officer, that is Nyayadhikari, shall be appointed by the state government. In consultation with the High Court. The Gram Nyayalaya shall be the court of the judicial magistrate of first class and its presiding officer. In the case of the permanent Lok Adalat, the chairman, due to the state jail chief is Badam, the size of additional assessors or position higher than that, and 1 plus 2, that is 2 other members. Okay, and we got 1984. establishment by the state government in consultation with the High Court. The Gram Nyayalaya shall be court of judicial magistrate of the first class. And its presiding officer, that is Nyayadhikari, shall be appointed by the state government in consultation with the High Court. The Gram Nyayalaya shall be established for every panchayat at intermediate level. Gram Nyayalaya shall be established for every panchayat at intermediate level, or a group of contiguous panchayat at intermediate level in district, or where there is no panchayat at intermediate level in any state, for a group of contiguous panchayat. Nyayadhikari will preside over this gram panchayat as strictly judicial officers. जो न्याय अधिकारी होंगे ये strictly judicial officers होंगे and will be doing the same, directly deriving the same powers as first class magistrate working under High Court, and will be doing the same, deriving the same power as first class magistrate working under the High Court. The Gram Nyayalaya shall be mobile court and shall exercise the power of both criminal and civil court. ये mobile होना चाहिए, mobile court and shall exercise the powers of both the criminal and civil court की दोनों की power होनी चाहिए. The seat of the Gram Nyayalaya will be located at the headquarter of the intermediate panchayat, और जो seat होगी located at the headquarter of the intermediate panchayat, they will go to the villages, work there and dispose of the cases. The Gram Nyayalaya shall try criminal cases, civil suit, claims of dispute which are specified in the first schedule of the second schedule to the Act. The central as well as the state government have been given power to amend the first schedule and the second schedule of the respective legislation. Central as well as the state government have been given power to amend the first schedule and the second schedule of Act as per the respective legislative competence. The Gram Nyayalaya shall follow summary procedure in criminal trial. The Gram Nyayalaya shall try to settle the dispute as far as possible by bringing about conciliation. The Gram Nyayalaya shall try to settle the dispute as far as possible by bringing about conciliation between the parties, and for this purpose it shall make use of conciliators to be appointed for this purpose. Judgment and all parties of the Gram Nyayalaya shall be deemed to be decreed or delay in its execution. The Gram Nyayalaya shall follow summary procedure for its execution. The Gram Nyayalaya shall not be bound by the regular evidence provided in the Indian Evidence Act, but shall be guided by the principle of natural justice and subject to any rule made by the High Court. Appeal in criminal cases shall lie to the Court of Session. Appeal in criminal cases shall lie to the Court of Session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. Appeal in civil cases shall lie to the district court, and appeal in the civil cases shall lie to the district court. Appeal in civil cases shall lie to the district court. Appeal in the civil cases shall lie to the district court, which shall be heard and disposed of within a period of 6 months. A person accused of an offence may file an application for plea bargaining, establishment, the settlement, the non-economic expenditure, and the establishment of these Gram Nyayalaya subject to a ceiling of 18 lakh, out of which 10 lakh is for construction of the court and 5 lakh for vehicle and 3 lakh for office equipment. The non-recurring expenditure and the establishment of these Gram Panchayat more than under the Act, for which the central government would provide 1400 CR by way of assistance to the concerned state and UTs under the Gram Nyayalaya 2008. Therefore, the state government established Gram Nyayalaya in consultation with the respective High Court. Gram Nyayalaya 2008 is for the state government established Gram Nyayalaya in consultation with the respective High Court. Majority of state have now set up regular court at taluka level for the reluctance of police official and other state functionaries to invoke jurisdiction of Gram Nyayalaya. Leave go on. Response of the bar. Non-availability of notaries and stamp vendors, problem of concurrent jurisdiction of regular court, or other issues indicated with the state which are coming in the way of operationalization of the Gram Nyayalaya. The issue affecting operationalization of the Gram Nyayalaya was discussed in the conference of Chief Justice of High Court and Chief Minister of the state in April 2013. The issues affecting operationalization of the Gram Nyayalaya were discussed in the conference of Chief Justice of High Court and Chief Minister of the state in April 2013. It was decided in the conference the state government and the High Court should decide the question of establishment of Gram Nyayalaya wherever feasible, taking into account their local problems and focuses on setting up Gram Nyayalaya in taluka where regular courts have not been set up. The original constitution did not contain provision with respect to tribunals. Okay. The 42nd Amendment original constitution did not contain provision with respect to tribunal. The 42nd Amendment Act of 1976 added new Part 14 into the Constitution. The part is entitled as Tribunals and consists of an two article, that is Article 323A and 323B. 323A dealing with administrative tribunals and Article 323 dealing with the tribunals for other matters. Tribunals for other matters. Administrative tribunal. Article 323 empowers Parliament to provide for the establishment of administrative tribunal for the adjudication of dispute relating to recruitment, condition of service of person appointed to public service of the centre, state, local bodies, public corporation, public authorities. Relating to the recruitment and condition of services. Article 323 enables the Parliament to take out the adjudication of dispute relating to service matter from the civil court and the High Court and place it before the Administrative Tribunal. In pursuance of Article 323, the Parliament has passed the Administrative Tribunal Act in 1985. In pursuance of Article 323, in pursuance of the Article 323A, the Parliament has passed the Administrative Tribunal Act in 1985. The Act authorizes the central government to establish one central. In pursuance of Article 323A, the Parliament has passed the Administrative Tribunal Act in 1985. The Act authorizes the central government to establish one central administrative tribunal and the state administrative tribunal. This Act opened its in the sphere of providing speedy and inexpensive justice to the aggrieved public servant. Providing speedy and inexpensive justice to the aggrieved public servant, Central Administrative Tribunal. The Central Administrative Tribunal was set up in 1985 with the principal bench at Delhi. With its principal bench at Delhi and additional benches in different states represented by 17 regular benches. The Central Administrative Tribunal was set up in 1985 by the Administrative Tribunal Act of 1985 with the principal bench at Delhi, and at present there are total 17 regular benches, 15 of which operate at the principal seat of High Court and the remaining two at Jaipur and Lucknow. 15 of which operate at the principal seat. This makes it 15 operate at the principal seat of High Court and the remaining two at the Jaipur and the Lucknow. These benefit also circuit sitting at other seats of High Court. The CAT exercises, CAT in the Central Administrative Tribunal exercises original jurisdiction in relation to recruitment and all service matters of public servant covered by it. Jurisdiction extends to all India services and central civil services. Civil person, the center and civilian employee of defense services. However, the members of the defense forces, the president, servants of the Supreme Court and secretarial staff of the Parliament are not covered by it. However, the members of the defense forces, under the civilian employees of the defense forces. Okay. However, the member of the defense forces, officers and servants of the Supreme Court and the secretarial staff of the Parliament are not covered by it. The CAT is a multi-member body consisting of a chairman and members. Originally, the CAT consisted of a chairman, vice chairman and members. Later in 2006, the provision for the vice chairman. In 2006, the provision for the vice chairman was removed by the Administrative Tribunal Amendment Act 2006. Hence, there are no vice chairman in the CAT. At present, sanction strength of the chairman is 1 and sanction strength of the member is 65. They have done from a judicial and administrative seats and they are appointed by the president. They hold office for a term of 5 years or until they attain the age of 65 years in case of chairman and 62 in the case of members, whichever is earlier. That is they are appointed by the president. They hold office for a term of 5 years. And appointed by the president. They hold office for a term of 5 years until they attain the age of 65 years in case of chairman and 62 years in case of member. 65 years in case of chairman and 62 years in case of member, whichever is earlier. The appointment of members in CAT is made on the basis of recommendation of high-powered election committee chaired by sitting judge of Supreme Court who is nominated by the Chief Justice of India. The appointment of members in CAT is made on the basis of recommendation of a high-powered selection committee. The appointment of members in the CAT is made on the basis of recommendation of a high-powered selection committee chaired by sitting judge of a high-powered selection committee chaired by a sitting judge of Supreme Court. The appointment of members in a Central Administrative Tribunal is made on the basis of recommendation of high-powered selection committee. The appointment of members in Central Administrative Tribunal is made on the basis of recommendation of high-powered selection committee chaired by a sitting judge of the Supreme Court who is nominated by Chief Justice of India. The appointment of members in Central Administrative is made on the basis of a recommendation of a high-powered selection committee chaired by a sitting judge of Supreme Court who is nominated by CJI. After obtaining the concurrence of CJI, appointments are made. After obtaining the concurrence of the CJI, appointments are made with approval of Appointments Committee of the Cabinet. It was found by procedure laid down in CPC 1908. It is guided by the principles of natural justice. It is guided by the principles of natural justice, only a nominal fee. These principles kept the Central Administrative Tribunal flexible. These principles kept the Central Administrative Tribunal flexible in approach. Only a nominal fee of ₹50 is to be paid by the applicant. Applicant may appear either in person or through a lawyer. Originally, appeals against the order of the CAT could be made only in the Supreme Court, or appeals against the order of the CAT could be made only in the Supreme Court and not in the High Court. However, in the Chandra Kumar case 1997, the Supreme Court declared that this restriction on the jurisdiction of the High Court as unconstitutional. The Supreme Court declared that this restriction on the jurisdiction of the High Court as unconstitutional. Holding that judicial review is a part of the basic structure of the Constitution, it laid down that appeal against the order of the CAT shall lie before the divisional bench of the concerned High Court. Appeals against the order, it laid down that appeal against the order of the CAT shall lie before the divisional bench of the concerned High Court. Consequently, now it is not possible for an aggrieved public servant to approach the Supreme Court directly against the order of the CAT without going to the concerned High Court. So, in the Chandra Kumar case 1997. So it said that in the Chandra Kumar case 1997, the Supreme Court declared that the jurisdiction of the High Court as unconstitutional. Holding that judicial review is part of the basic structure of the Constitution, it laid down an appeal against the order of the CAT shall lie before the division bench of the concerned state High Court. State Administrative Tribunal. The Administrative Tribunal Act of 1985 empowers the central government to establish a state administrative tribunal on specific request of the concerned state. On specific request of the concerned state government. So far, this had have been set up in 9 states of Andhra Pradesh, Himachal Pradesh, Odisha, Karnataka, Madhya Pradesh, Maharashtra, Tamil Nadu, West Bengal, Kerala. However, the Madhya Pradesh, Tamil Nadu, Himachal Pradesh tribunals have been abolished, but subsequently Himachal Pradesh established a SAT in the state of Tamil Nadu has also requested now to re-establish the same. Further, the state government of Haryana was requested to establish a SAT for the state. On the other hand, the state government of Odisha submitted proof that the abolition of Odisha Administrative Tribunal, like the CAT, the SAT exercise original jurisdiction in relation to recruitment and all service matter of state government employees. Recruitment and all service matter of state government employees. The chairman and member of the board are appointed by the president after consultation with the governor of the state concerned. President, after consultation with the governor of the state concerned, the act also make a provision for setting up a joint administrative tribunal for 2 or more states. A J8 exercise all the jurisdiction and powers exercisable by the administrative tribunal for such state. Chairman and members of the SAT are appointed by the president after consultation with the governor of the concerned state. After consultation with the government with the concerned state, appointed by the president, and the appointment of member in CAT are made on the basis of recommendation of high-powered selection committee chaired by sitting judge of Supreme Court, who is nominated by the Chief Justice of India. Tribunals for other matter under Article 323B, the Parliament and the state legislature are authorized to provide for the establishment of tribunal for adjudication of dispute relating to the following matter: taxation, foreign exchange, import and export, industrial and labor, land reform, ceiling on urban property, election to of forced of rent and tenancy right. Article 323 and 323 differs in the following 3 aspects. While Article 323 contemplates establishment of tribunal for public service matters only, other matters of the tribunal 323 can establish only by Parliament. The Parliament and state legislature, both by the Parliament and the state legislature.